My Lord, I wonder if I could just deal with the point that was raised.
Yes, I hoped you might.
Thank you
will.
very much. In discussion with Mr. Udin, and having had sight of some email communication with his Lordship's clerk, Miss Pavley, I can answer my Lord's questions. First of all, Mr. Udin and the other advocates didn't have knowledge of the transcripts before the submissions were filed. Submissions were filed, and there are a series of emails on the 3rd of November between Mr. Udin and Miss Pavley, his Lordship's clerk, when Miss Pavley sends, first of all, forgive me, on the 27th of October, forgive me, Miss Pavley sends the draft judgment, and in that draft judgment, attached to the draft judgment is her email indicating that his Lordship would like any editing responses by the 10th of November. On the 3rd of November, Mr. Udin writes to Miss Pavley, and he indicates that his instructing solicitor, my instructing solicitor, has learnt from the court office that his Lordship had obtained the transcripts of the evidence. So,
sorry, when did Mr. Udin says this, or his solicitor say this?
So Mr. Udin learnt from the solicitor around the 3rd of November that the court, from the court office, that his Lordship had obtained the transcripts of the evidence.
Sorry, I'm being slow. Mr. Udin learns from his solicitors or from the court office?
He learns from his solicitor, who learns it from the court office.
He emailed the judge saying, emailed the judge's clerk saying
Yes.
that his solicitor had learnt from the court office that the judge had received the transcripts.
Indeed, correct. And he then requests in that exchange whether the transcripts could be made available before the judgment is perfected. He's raising an inaccuracy in relation to paragraph 99 of the judgment. So he's raising it from recollection in the email exchange because he doesn't have the transcript.
Yeah.
As I say, he requests access to the transcript before making editorial comment. Miss Pavley, again, these exchanges are all on the 3rd of November. Miss Pavley responds. I think there's only one email, forgive me, in fact, from Miss Pavley back, and that email indicates that if the transcripts are wanted, then they would need to be paid for. So therefore the transcripts are never provided to the advocates. The time at which the transcripts are obtained was after and seen by counsel, after the appeal was issued.
Yes, I see.
So the judgment gets handed down, that's finished, and then the appeal proceeds.
Yes, indeed.
So, but the judge's clerk implicitly accepts that the judge has a copy of the transcript.
Yes, no question.
Does she?
about it.
She
Yes,
says that, does she?
he's got the transcripts, yes.
She says that.
She says that, and I can forward these through the...
Well, I'm assuming you've shown them to Mr. Wilson
Well,
already.
Mr. Wilson was copied in on all of these emails.
Yes, so I assume
I've
yes.
discussed them with him. And-
Fine. I'm sure you've summarised them accurately. We'll just double check with Mr. Wilson in a moment.
Yes.
So the reply was the 3rd of November
Yes.
as well. And you
Yes,
say
it's
that
paper.
in that email, counsel clerk confirms that the judge has the transcripts.
It says in terms, dear Mr. Udin, yes, his Lordship did have the transcripts when preparing his judgment. If you wish copies of the transcripts, you may order them and pay for them through the court office. That's the 3rd of November, 151.
And meanwhile, Mr. Udin has put at least to the clerk that there is an issue about paragraph 99, which was the paragraph we were
Yes.
discussing.
So it would be helpful to see those.
Sorry? I think we'd better have those emails. I don't think anyone is sort of ready. Well, remind me when the judgment was finally handed down. I thought it was in October, but
That was the draft judgment.
No, I understand that, but I had thought the final handout
That's what
was
we
October.
thought was, that's what we've got.
15th of November was the final.
15th
Yes,
November.
final.
The date's wrong.
So the date on the judgment's
I
wrong.
noted it said the 27th, yes.
Of August, is it?
It was dated the 25th of October 2021, in what we've got at page
Yes.
39.
It clearly wasn't, because the draft was only sent out of these emails on the 27th of October.
Sorry, let's just bottom this out. Yes, I'm afraid that's what I wrote 25th October on it. And, so that's wrong, is it?
Yes, well, the email...
How do we know it was 15th of November?
That's Mr. Udin's recollection. I don't know if Mr. Wilson has a recollection in relation to that. Email, there's an email confirming.
Oh, how very odd. I don't for a moment doubt it. Where's the order?
Is the order the previous page? Is that the order? Because that's dated the 27th of August.
That can't be right either, can it?
Mr. Udin, is this? There are some emails, certainly the email of the 27th of October from Ms. Pavley makes it quite clear that's when the draft is being sent. So it's inconceivable it was finalised by the 25th because, of course, she's only sending it out.
No, quite. I know. I'm sure it was an error. It's just very unusual.
Yes,
well,
no,
of course, we all
You
make
won't know
mistakes.
this when you're using the transcript. It's unclear. When you're using the software, it says something, doesn't it? It alerts you to the fact you haven't put the judgment date in.
I'm afraid I can't assist any further, but we may have a date as to when it was finalised.
I think we, simply so that the judgment is accurate, I think we should have the date when it was formally handed down in court, or no doubt it wasn't done in court, but it was formally handed down. And we should have the date of the order. It's really a matter for the parties how pedantic they want to be, but I would have thought, frankly, this is a matter that ought to be drawn to the attention of the court, certainly if the date on the order is wrong, because sometimes dates actually matter.
Yes.
The list will have it. The judgment would have been listed.
Yes. Yes. May I just turn my back?
And done.
Judgment, my lord, was formally, there's an email from Miss Pavley on the 15th of November, and in that email she indicates, good morning, please find attached final judgment of Mr. Justice Keehan. This is deemed handed down at 9 AM on Monday the 15th of November.
15.
Well, that's very useful. But just if Mr. Udin has the attachment there, just click on the attachment and see if it is exactly the same as the version we've got here, or whether it has the correct date. Okay, well, if that can't be done now,
My lord, we can't do it immediately, but we'll endeavour.
I think it would just be. I mean,
well, if Mr. Udin has an email with it on, he could forward that to one of our clerks. Just say I've been asked to forward this by the court.
Yes, yes, of course.
and just while we're on this point, I hadn't even bothered to raise before, but it slightly puzzled me. Page 468. The first fact-finding judgment, 17th of April 2020, the version that we have at 468 doesn't have the neutral citation number, which again, as my lord says, those familiar with the software, certainly the software we use in the Court of Appeal, you can't actually hand down without a neutral citation.
Same with High Court. It's the same software.
So this doesn't look like the absolutely final version, but perhaps it is. Maybe something's gone wrong. You see where it says
Yes,
top
yes,
left,
I do
you
have
double.
Yes.
Do you have a version with the correct?
My lord, having come to the case very late.
No, sorry. This is very. You weren't
No, not
expecting
at
this
all.
anyway. Well, look.
My lord, I can certainly make inquiries through.
I think it's not. It's of no substantive importance, but it's always a slight concern to me where, and one does see cases where it really does matter, where we haven't actually got the authentic version. So I think if you could follow that up.
Of course.
Thank you.
Thank you, my lord. Can I assist in any other way?
No, you've been helpful, both generally and just now.
Thank you.
Thank you. Yes, Mr. Wilson.
My Lord, I wonder if I might begin by addressing those points, because
Yes.
I've been involved throughout.
Yes, certainly.
The version of the judgment dated the 17th of April that's in the bundle is, I think, the same version that has been used in the bundle at first instance since that judgment was handed down. Certainly the judgment that has been being used has the same lack of a neutral citation number, and I'm not quite clear why that is.
Okay, well, thank you for pointing that out. Ms. Ancliffe has kindly agreed just to look into that in your solicitor, whatever help
Yes.
is necessary. Thank you. Yep.
The second point is that the order is dated the 27th of August, which is obviously wrong, because that was the
There's
final
no
day of the
decision
hearing,
at that point.
and there was no, as the court will know, there was no indication given or any decisions made at that point in time.
No.
I can't remember quite the date, because the order is not in the appeal bundle, but the appellant applied for permission to appeal to this court at some stage prior to October or November, when the court circulated the draft judgment and then handed down the final version. And at that point in time...
Well, they applied for permission before the final handout.
Yes, in relation to the recusal application.
Oh, I see, because that had been
Yes.
made. Yes, I see, yes,
And
of course.
my Lord Justice Peter Jackson made an order at that time. That order is not in the bundle, so far as I'm aware, that effectively adjourned the appeal pending the handing down of the substantive judgment, and also directed the appellant to obtain transcripts. And so it was in the course of that,
Yes, I see.
those inquiries that led to the parties being informed that His Lordship Mr. Justice Keehan had obtained the transcripts.
Oh, sorry. So are you saying that what otherwise struck me as slightly odd, I'm sure it occasionally happens, the judge had bespoken copies? I can't.
No, not at all. I'm not suggesting there was any link between those two things. That simply explains why I think inquiries were made by those who instruct Ms. Ancliffe and Mr. Riddin of the court office, because the appellant had been directed by this court to obtain transcripts.
Oh, so they thought, well, maybe the judge has a copy.
Well,
Who knows?
I don't
Okay,
know.
it really doesn't.
No.
That doesn't matter. Right, and the order, as you say, the order is misdated. I do think, for good order's sake, somebody should go back to the appropriate court office and get it amended with the correct date,
Yes.
so that everyone knows what that date was.
Yes.
Probably won't matter, but you never know.
And sadly, as sometimes happens, that date would have been later than the 15th of November, because there were discussions about how to properly...
No, well, that doesn't surprise me. But there will have been a date
Yes.
as at which it was formally
Yes.
formally made. Yes.
Yes.
Yep. Okay. Thank you.
My Lord, my Lady, then the respondent opposes this application, or this appeal rather, and he does so on the basis that the fair-minded and informed observer, when standing back and taking into account all of the relevant information, viewing the proceedings as a whole, would not consider that there was a real possibility that His Lordship was biased against the appellant, or at all. From the outset, I recognise on his behalf that, on one view, this is a relatively narrow appeal. It's concerned only with the tribunal that hears the final hearing at the end of this month. And the court will appreciate that, of course, from the respondent's perspective, that is the hearing that he is particularly concerned about. And regardless of tribunal, it's imperative, as I think the court indicated this morning, that final welfare decisions are made. As I understand it, at the permission hearing at the beginning of April, the aim of Lord Justice Peter Jackson was to obtain a fallback listing.
Yes.
As we understand it, that has not been done, and I'm conscious that it's not easy, in fact near impossible, I suspect, to find 5 days of a High Court judge's time to be able to fit matter in, even if lists were swapped. So I don't know if that has happened. We've been told that it hasn't, but those are on the basis of very limited inquiries. But I raise that because, although of course I accept, and this is in the authorities, that practical considerations should not and do not factor into the question of apparent bias, the reality is, as I understand it, it may be that the matter can't be concluded at the end of this month if His Lordship is not to be the judge that hears the final hearing. But as I say, I accept from the outset, it's in the Bubbles and Wine case at tab 9, that that's not a relevant consideration. Before I address each of the instances that are relied upon, and some of them I hope I can take relatively briefly, there are two separate general points that I wish to make, if I may. The first concerns the approach to the question of whether or not there is or a risk of apparent bias. And I agree that the legal framework is well settled, but in light of some of the submissions made this morning, if I may, I would just pick out on two particular points. The first is the interplay between the question of unfairness and the question of bias. And as the court indicated this morning, they overlap, but they are distinct with different tests. If I might very briefly ask the court to look at the case of Serafin and Malkovich at tab 10 of the authorities.
We don't, for my part, I don't have tabs. What page number?
Forgive me. That is page 348.
I do have an index which said that, so I'm sorry, Mr. My mistake.
A bit surprised. No, sorry, keep going. No. Ignore what I just said.
This was the decision of the Supreme Court, and I should say that this appeal was squarely on the basis of unfairness rather than bias. But if I might just take the court, please, to page 357. And in particular, paragraphs 37 to 39.
Remind me whose judgment this is.
Lord Wilson.
Lord Wilson, yes.
And I simply flag this reference because this discusses to a limited extent the parallels between unfairness and bias, and makes reference to the case in paragraph 38 of M&P Enterprises Limited and Norfolk Square, Northern Section Limited. That is an authority to which I refer on a number of occasions in my skeleton argument. Unfortunately, and I make no criticism, that is not in the... It was in the original form of the authorities bundle, but not in the revised one filed yesterday. And I didn't wish to burden the court by sending yet more loose paper because I don't tend to refer to it to any great...
Well, presumably you only refer to it by paragraph numbers, don't you? So does it make any difference?
No, it doesn't at all. So I simply flag that to say that it's the Supreme Court there, Lord Wilson, refers to and implicitly approves the discussion by the judge, Mr. Justice Hilliard, in M&P as to the difference between the two. And I simply flag that because there was some overlap between submissions as to fairness and submissions as to the appearance of bias. So I simply flag the reference because it provides the authority for the proposition that the court already made and I think is accepted as to the distinction but the overlap between them. And all I simply noticed that at paragraph 39, towards the end of that paragraph, Lord Wilson makes the point that on the assumption that the definition of apparent bias that's referenced in the Bubbles and Wine case and also M&P is correct, it would be far more clear in that particular case that the observer would consider the judge had given the appearance of bias, even though the appeal was ultimately allowed on the basis of unfairness. So I simply draw the court's attention to that because it, not for now, and I don't think there's any dispute about this, and I flag it in my written document, but that analyses the interplay between the two. The second and perhaps more important point in my submission is in the Bubbles and Wine case, which is at 335. Yes, my lady. And paragraph 17, this court summarised the relevant principles applicable to a claim of apparent bias.
17.
Paragraph 17, yes, 17 to 19. At paragraph 17, towards the bottom, 3 and then 4 lines up from the bottom, the point is made that bias means a prejudice against one party or its case for reasons unconnected with the legal or factual merits of the case. That's well established. I simply flag that. And then over the page at paragraph 19, given the way in which some of the submissions were made this morning, I simply flagged the point that it is made very clear in paragraph 19 that the test is, or forgive me rather, the fair-minded and informed observer is not to be confused with the person raising the complaint. The test ensures that there is that detachment. And so, with respect, if I may, this morning I think there was reference to the test being the fair-minded or informed observer in place of the reasonable client. Perhaps
I think I used that phrase. May not be quite accurate. But I'm not sure it's really wrong. I think the point I was simply making was that the person with the greatest interest in it being fair is the client, and in particular the losing client. And the way you test whether their perception is, whether they have suffered, their perception is fair, is to see what a reasonable observer would have said.
Absolutely not. But I think you make the point that there is that element of detachment because of the way that some.
Oh, we know it. It's not just it's crucial. Yes.
And perhaps taking that one step further, the final sentence of that paragraph is that if the test is not satisfied, then the objection to the judge must fail, even if that leaves the applicant dissatisfied, bearing assent to the justice will not or may not be done.
That's quoting the previous master rules.
Yes. And so I simply flag that as as a response, perhaps, to the way in which some of the submissions were made.
With what consequence do you say then? Are you going on to say that the judges, just so I'm clear, insofar as the judge indicated any view which was contrary to that of the appellant, it arose out of reasons connected with the case rather than anything unconnected with the case, and therefore we're not in a situation of apparent bias? Is that what you're saying?
That's the first point, and the second, perhaps more substantial point, is that insofar as the appellant feels that she will not have a fair hearing, which is how the case has been put, and in fact, in fairness to her, it is how she has expressed herself even before this application for recusal was made, insofar as that is a basis for the appeal or a submission that is made, in my submission that is irrelevant, because it's not about the test for apparent bias. Relying upon that paragraph 19 is not about whether or not a particular litigant feels that they will have a fair hearing, but about whether the fair-minded and informed, perhaps I would add to that, detached observer would consider that there was a real possibility of bias. None of this, I don't, in my submission, is particularly controversial. I'm simply flagging it because of how the submissions were put and the fact that on I think more than one occasion the point was made that the appellant doesn't feel that she would have a fair hearing. But of course, as I say, that's not the test.
Lord Justice Legate's phrase, which he takes from a couple of, at the end of para 17, was obviously a slight question mark being put by Lord Wilson as to whether that was a little bit too narrow. But at the moment, it's binding authority, so far as we're concerned, isn't it?
Yes, and in my submission, Lord Wilson wasn't perhaps casting any doubt or querying it, rather saying that because nobody had mentioned bias, the court hadn't been addressed on bias, although on one reading of the Court of Appeal, in that case's judgment, it came close to suggesting that that was a factor because they hadn't been addressed on it and because that wasn't how the case was put.
No, it's clearly open. Anyway, there we are. Yes.
Those are the only points I wish to make about the legal framework. The second more general point, if I may, is about rather is that the starting point for this court should be viewing the proceedings as a whole, and the authority for that proposition is cited at paragraph 23 of my skeleton argument. I don't ask the court to go there, but it's the case of Singh and Secretary of State for the Home Department, where the point is made that the court has to view the proceedings as a whole, and in my submission that should be the starting point, of course looking at the individual instances, but the starting point should be looking at the proceedings as a whole. And when doing that, few points I wish to make. The first is that, as has been accepted this morning, any analysis has to take place in the context of the unchallenged findings, and there are many of them, as to the appellant's conduct. And those findings are not only findings of serious dishonesty in relation to fabricated allegations, not just once, but over a period of time, but also findings of behaviour which, even for cases in the family division, are unique in the profound impact that they will have for the child at the centre of the proceedings. The findings in relation to the conception of the twins will, on any view, in my submission, have or create exceptionally complex identity, psychological and emotional needs for the child. That is the welfare context in which decisions are being made, and it's in that context that, in my submission, the complaints have to be evaluated. I also very briefly make the point that insofar as the hearing in August of last year was a determination of any factual matters, that was the third occasion on which the court had come to determine factual issues, because the appellant had been given two opportunities, once in January 2020, and then again in July 2020, to make allegations and for those allegations to be determined. And I say that because the court conducted, if I recall correctly, a 4-day fact-finding hearing in the beginning of January 2020. But then, following an aborted attempt at a final hearing in April of 2020, the appellant was permitted by his lordship to raise further and new allegations that predated the January 2020 fact-finding hearing, which she said were relevant. So, when viewing the proceedings as a whole, in my submission, the court can't simply start at the March 2021 hearing, but viewing them all as a whole, the appellant has been given throughout, in my submission, the opportunity to put her case and to raise matters which she says are relevant to the welfare issues. But even looking only at the hearing from August of last year, in my submission, again, looking at the hearing globally, because of course we know it took 5 days, apart from the exchange in relation to instance number 8, which I'll come back to, and in saying this, I take that at its absolute highest, there was no point in my submission that the appellant was prevented by his lordship from putting her case. I don't accept the way in which that's put in relation to instance 8, but even taking that at its highest and putting it to one side, aside from that, her case was put fully. The hearing was listed for 3 days, and in fact it took 5, and I bear some responsibility for that, I accept, but equally, the time estimate that was given for her cross-examination, or rather cross-examination on her behalf of the respondent, was 1.5 hours in the witness template, and in fact we can see from the transcript it took almost an entire day. There was no, his lordship did not prevent any challenge being made to the respondent's evidence, and in the same way, there was, aside from instance number 8, which I'll come back to, there was no prohibition or restriction on the ability of counsel for the appellant to challenge or put matters to the children's guardian. Equally, somewhat unusually, but not for the first time in these proceedings, during the course of her own evidence, the appellant sought to adduce a raft of new documentary material. In spite of my objections to that, his lordship permitted that material in.
Could you just, for my benefit, just give us the note in the transcript?
Of course, at
where we
page
find it.
388. Perhaps, if I might very briefly turn to that. In fact, forgive me, that's entirely the wrong reference. May I find the reference in a moment?
Yes, I'm sorry.
Look, not only was she permitted to adduce that evidence, but at the conclusion of her evidence, again, contrary to my submissions, the appellant was permitted by his lordship to address the court as to what that material showed, and she was given a time period. It's in the transcript, I'll find the reference, of 20 minutes to do that, but she was permitted to adduce all of the evidence that she wished to adduce, and that's an important factor in my submission. particularly because, as I say, that is an unusual course of events, and no complaint in my submission at all could have been made if his lordship had said, no, you're in the middle of your evidence, I'm not permitting any further material to be adduced. But his lordship did not take that approach. And finally, although I accept the position of the Guardian now, having seen the transcripts, is to support, although on slightly different grounds, the appeal, I simply make the brief point that at no stage during the course of the hearing did counsel for the child, who had been involved in these proceedings, not quite as long as I have, but for a considerable period of time, and at least since the first fact-finding hearing, at no stage were any objections raised on behalf of the child as to the conduct of his lordship. And the final point about looking at this more generally and from a wider perspective is to look at the outcome of the hearing, because it's important to note that it was a central part of the respondent's case that the proceedings needed to end in August. That was at the forefront of the presentation of his case, and yet his lordship did not accept that, and as I'll come on to in a moment, adjourned largely on the basis of giving the respondent an opportunity to move forward, the appellant,
yes,
the opportunity of moving forward, reflecting in light of any decision on the part of the Crown Prosecution Service, and I'll come to the reference in his lordship's judgment to that in a moment. But his lordship also refused all of the respondent's applications in relation to limiting the appellant's parental responsibility. Again, I'll come to the reference to that in a moment. And also expressed a relatively clear view in his judgment that, contrary to the respondent's view, a family assistance order would be appropriate. That is an order that can't be imposed by the court on a parent. It can only be made if the individuals named in it consent to the order being made. And his lordship gave it was supported by the appellant, and his lordship in his lordship's judgment and during the course of the hearing gave a relatively clear view about that. But if I might ask the court briefly to turn, please, to page 70 of the bundle. And this is his lordship's judgment. At paragraphs 175 and 176, it's right to say that his lordship expresses a view about the prospects of any change. However, I cannot ignore the fact that the child loves his mother very much and enjoys having contact with her. I can only make an informed decision about future contact in light of medical issues, but also the decision of the Crown Prosecution Service and the appellant's reaction to the same. And again, at paragraph 176, I know that the child enjoys seeing his mother, and therefore his best interests require me to have the best evidence available to determine where the balance of harm falls between frequent and unrestricted contact, or sadly, very infrequent and supervised visiting contact. And there's 2 points I would make about that. The first is that that has relevance when we come to look at the guardian's evidence in due course, and in particular the exchange in relation to instance 8. And what I will be saying at that point is that the point that is made by the guardian is to some extent, not entirely, I accept, I don't push the submission too far, but is reflected in his lordship's judgment. But more importantly, in my submission, the very long-running proceedings, which by that point, August of 2021, had been ongoing for 3 years, were again adjourned in part, and no small part, to give the appellant the opportunity to reflect on her views. And again, in my submission, that is a relevant factor when considering the issue of apparent bias. And just for the court's reference, it's paragraph 189, where his lordship deals with the refusal of the applications in relation to parental responsibility. But I don't ask the court to turn to that. And so, when looking at each of the individual instances in my submission, the fair-minded and informed observer, and by extension this court, has to place them, in my submission, squarely in that context, both as to how the proceedings had been managed up to the August hearing, how they were managed from a more general point of view during the August hearing, and then also the outcome of that hearing. His Lordship, Lord Justice Peter Jackson, at the Permission to Appeal hearing, put it that there was something in the judgment for both parents, which is correct in the sense that certainly the two fundamental planks of the respondent's position were not acceded to. And so in that context, if I may, I'll turn to each of the instances. Some I can address more briefly than others, and I'll broadly, if it assists the court, attempt to follow the same order that was followed on behalf of the appellant, but it may be that I jump around a little if I may. So looking first at the instance number 2 and the judge's approach to the medical evidence in March of 2021. And of course that hearing, the final hearing on the 25th and 26th of March 2021, had been listed the previous year in July 2020. The July hearing was intended to be a final hearing. In fact, the April 2020 hearing was intended to be a final hearing. That couldn't happen for various reasons that are obliquely referred to in his Lordship's judgment. It was then adjourned to July, and that was intended to be the final hearing. But on the following the position of the Guardian, his Lordship adjourned again for the instruction of expert evidence. It was then listed on the 25th and 26th of March. So, of course, all of his Lordship's actions have to be seen in the context that this was the third attempt at a final hearing. At that stage, some 2.5 years after the start of these proceedings. And of course, I know these proceedings have been going on since about 3 or 4 months after the child's birth, so almost his entire life. And the chronology, I think the court has, but very briefly, it was during a hearing on the 16th of March that had been listed for some time, that during the course of the hearing, not previously, the appellant raised that she wouldn't be able to attend in person because of health issues, and limited information was given at that point in time. And by way of context, aside from the April 2020 hearing, which was very soon after the first lockdown, both the January 2020 hearing pre-pandemic, but also the July 2020 hearing shortly after restrictions were relaxed, took place in person in relation to each of the parents' evidence. It was hybrid, but they both gave their evidence in person. And so that had been the assumption on which everybody had been proceeding. During the course of that hearing, the appellant indicated that she was going to apply to vacate the hearing on the 25th and 26th of March, and directions were given for evidence to be filed. The court has heard about that. Of course, the respondent still hasn't seen the material that went to the judge, and that's proper. I make no complaint about that. It's very sensitive personal information, and the court will appreciate, by virtue of the work that the respondent does, he appreciates that. But it's very clear from his Lordship's judgment that there was not sufficient information in the material, and it seemed to be being accepted this morning that that may have been the case, and that it was perfectly proper for his Lordship to require further evidence. As I understand it, the way that this complaint is now put is not that his Lordship cast doubt on the diagnosis, but rather cast aspersions by saying that he was suspicious about the treatment starting on that particular day, which is a slightly different way from how it's been put previously. But ultimately, what happened was that the judge required further evidence. His Lordship's judgment is very clear about that. The application could be renewed. That further evidence was supplied, and in very short order, it's clear from the transcript of the 25th of March that his Lordship granted that application. If I might ask the court please to turn to the position statement that was filed on behalf of the appellant in advance of that hearing, which is at page 91A. I will come back to this in a moment, but if I might ask the court to look at paragraph 23 on page 91C. This was an authority that counsel for the appellant himself cited to the court in support of the application for an adjournment, and we can see over the page, page 91D, that paragraph 22 of the citation, if the tribunal or court has doubts as to whether the evidence is genuine or sufficient, the tribunal or court has a discretion whether or not to give a direction such as would enable the doubts to be resolved. Thus, one possibility is to direct that further evidence be provided promptly, as his lordship took on the 19th of March, or forgiving actually, on the 16th of March, and then again on the 19th of March. Another is that the party seeking the adjournment should be invited to authorise the legal representatives for the other side to have access to the doctor giving the advice in question. There was some suggestion raised this morning that this was a course that was taken both in August and in March. I don't recall it being taken in March, and it certainly doesn't appear to be referenced in the transcript of the 25th of March, but I'll come back to that point. But in any event, the appellant's position statement itself cites authority for the proposition that it is within the court's case management powers to make directions to obtain evidence. That's what the judge did. The evidence was obtained, and the matter was then adjourned. And again, when I make the point about looking at matters not just directly and in isolation, but as a whole, if we look at the transcript, which I'll come to in just a moment, of the hearing on the 25th, not only did his lordship adjourn the proceedings, there was an issue as to whether or not it should be adjourned for a shorter period of time, until June, which would enable all parties, and their representatives, save for counsel for the appellant, Mr. Dean, to attend, or 2 months later, in August, which would enable all parties to attend. And his lordship, as I'll take the court to in just a moment, disagreed with the submissions made on behalf of the respondent by me, and adjourned for an additional 2 months, in part to enable continuity of representation for the appellant. And the reference to that is at page 105 of the bundle. That's where submissions take place, and in fact the decision is at 106. Where his lordship says very much wishes that he could list the matter in June, but given the circumstances of the appellant, I do not consider it appropriate that she should have to yet again instruct other counsel. Also concerned about the reaction to medical treatment. And so that's relevant also in relation to instance number 3, but I'll come back to that in a moment. But in terms of the judge's approach to the medical evidence, in my submission, it cannot be said that the fair-minded and informed observer would consider that there was any real possibility of bias on the part of the judge in the way that he handled that. His lordship required proper evidence, which in light of the serial findings of dishonesty that had been made, in my submission was perfectly appropriate, and certainly not such as to give rise to an appearance of bias. That evidence was obtained. His lordship then adjourned the hearing, and adjourned it for a length of time, which was contrary to the submissions made by the respondent, and which enabled not only continuity of representation, but took into account the appellant's health needs. And in my submission, that is the sequence of events, and the fair-minded and informed observer would not consider that to give rise to the appearance of bias. The second part of that is that, as I understand it, is that complaint is also made about the approach that his lordship took in August to the issue of medical evidence. When adjourning on the 25th of March, his lordship directed that evidence be filed by the 23rd of July by the appellant, setting out information about her circumstances. I don't ask the court to turn there, but the order is at page 518 of the bundle for the court's reference. No such evidence was filed.
Sorry, remind me of the date, 23rd of July.
Yes.
4 months later.
Yes. No such evidence was filed by that date. an application was made by email, and the emails are in the court bundle. Again, unless it's helpful, I don't ask the court to turn there for the sake of brevity, but at page 589, on the 30th of July, the Lordship adopted the same position, which was requiring medical evidence of the appellant's inability to attend court. And picking up on a point Lord Justice Baker just made, of course, this was anticipated by those who represent the appellant for some 4 months that this was going to be an issue, but the evidence wasn't filed, and when the application to attend remotely was made, that was his Lordship's position. On the 4th of...
Forgive me, Mr. Wilson, for my part, I'm just looking at those. I just look at these. 590 is emailed from mother's solicitor. Had there been a change of solicitor by this point?
No.
Okay, mother's solicitor. And the response, I've got that wrong.
So, forgive me, if we start at 589, in fact, I apologise, that was, the court doesn't have in the bundle the application that was made by email, but the first application, but the response to that on the 30th of July is at 589.
So the application, sorry, 589 is a response by Ms. Paverley, the judge's clerk,
Yes.
to an email from the mother's solicitor.
Yes.
Copy to everybody.
Yes. And
Is it available, that email?
It can be. There were, I think, in an attempt perhaps to spare the court too many documents, they weren't included, but there were email exchanges with the court from both, on behalf of both parties, as to the approach that should be taken. That was the response. But then what followed is...
What was the tenor of the email? Was it asking for... What was it asking for?
For the appellant to attend the hearing remotely.
Was any reference made to the failure to comply with the direction about medical evidence?
I would need to double check, my lord, but as I understand it, or as I recall, it may be that those who represent the respondent pointed out that that hadn't been provided, and certainly there had also been inter partes correspondence which this issue had been raised throughout July, asking for the evidence in good time before the August hearing. In fairness to the appellant, that evidence was then provided, or some evidence was provided in the statement on the 4th of August, and the court has that statement at page 541 of the bundle. Again, I don't ask the court to turn there, but it didn't address the point that his lordship made, which was that it should be evidence relating to the appellant's ability to attend court, or inability to attend court, either generally or to give evidence. And where all of this takes us to is to page 595, and there are other emails, I can go through them individually, it's helpful, but they're all at the end of the bundle. But at page 595, on the 17th of August, which was the day before the hearing was due to start, counsel for the appellant emailed the court, emailed his lordship's clerk, by saying that the position had now changed, and not only was the appellant's case that she was unable to attend in person, but also that she was neither physically nor emotionally fit to attend at all. That had been a complete change of position that hadn't been raised before. And so again, it's in that context that his lordship requested that those who represent the child make inquiries in relation to the evidence, following what I accept is not a common occurrence, but certainly was envisaged in an authority that was cited by those who represent the appellant to the court earlier in March, an approach which had been sanctioned by this court in the Tynaz case.
So who suggested that the child solicitor contact
His lordship, Mr. Keehan. It's worth noting that the child solicitor did so and obtained the evidence that hadn't been filed by those who represent, by the appellant in relatively short order, because that material was obtained, and as we know from the transcript, His Lordship then permitted attendance remotely on the part of the appellant.
Yes, I hadn't, I'm afraid, grappled with all the details of this. At one point, she was saying she wouldn't give evidence remotely, or I would give it in person or remotely.
Yes, that was
595.
the email of 595.
But she resiled from that to the extent of being prepared to attend remotely.
Yes. And a point that His Lordship makes in His Lordship's judgment, but of course wasn't known to His Lordship at that point in time, is that email was sent at 3:30 on the 17th of August, saying moments ago instructions had been given that she couldn't attend at all, remotely or otherwise. But we know from disclosure from West Midlands Police that that evening, at I think about 2:45 in the morning, the appellant was.
Yes, I'm sorry. I now remember this passage. Yes.
Was working on the 6th draft of her statement for the Crown Prosecution Service. I accept, of course, that isn't relevant to the approach taken by His Lordship on the 17th of August, or even the 18th of August, because that wasn't known to the court at that particular point of time, or certainly hadn't been aired. But nevertheless, it shows in my submission the inconsistent and at times unhelpful approach that had been taken by the appellant to giving the court the relevant information that it needed to make these decisions. But ultimately, on each occasion, March and August, when the information is properly given, His Lordship makes the decision. And the decision, in my submission, cannot be criticised by the appellant as demonstrating anything in the way of apparent bias. And although I accept it's no longer pursued as a basis of this appeal, I do say it's relevant if we're assessing His Lordship's approach to the question of the medical evidence and any suggestion of apparent bias, that not only did he not, let me rephrase that, I was about to use a double negative, His Lordship permitted breaks very regularly throughout the hearing, not at 20 minutes, but at 40 minutes. I accept that's no longer being pursued as part of this appeal, but in fact, I rely upon it as evidence that His Lordship was adopting a perfectly proper approach to the appellant's health needs throughout. Unless I can assist any further in relation to the health issues, instance 2, I'll move on to instance 3, which is the brief exchange at the beginning of the hearing on the 25th of March. I hope the court will forgive me for going through the detail of the context so much, but that's because in my submission it's equally relevant to this question, where when looking at this and assessing His Lordship's approach, it has to be seen in the context of this potentially being, and then in fact being, the third final hearing in the proceedings that couldn't be effective and had to be adjourned. And so that is a relevant factor. Also a relevant factor when assessing His Lordship's response to the position statement is the fact that His Lordship had very clearly, expressly, in terms, permitted the application to be renewed on proper evidence. We see that from the note of the judgment, which, just for reference, I don't have what term there is, 516. Insofar as it's relevant, that position statement was, as I understand it, sent to the court, and I've checked this from my emails, on the morning of the hearing of the 25th at 6:19 a.m. And I do say that that's relevant contextual information. But ultimately, what is clear is that His Lordship was dissatisfied with the tone and or content of that position statement. And there are two points that I wish to make about that. The first is that the descriptions of impertinent and impudent, which His Lordship used at page 100, in my submission, I don't accept necessarily that criticism can be made of the use of those words, and the paragraphs that the court, cumulatively, if I might put it that way, identified are the paragraphs that I would rely upon in that document. And looking at this, my second point through the...
So you say they are arguably impertinent and impudent?
No, I thought you were saying the opposite. Sorry.
No, that's why I wanted to check.
Forgive me, I'm saying that...
I don't accept that criticism can be made of the words impertinent and impudent, or of the words in the position statement.
I don't accept the criticism of... Forgive me, let me stop using negatives. His Lordship, in my submission, was entitled to use those words. Other tribunals may not have used them, but I take the matter no further than that. But the tone of that document and the paragraphs that the court identified, in my submission, the fair-minded and informed observer would not have been surprised that some comment was made in relation to the tone of that document. And I say that particularly in the context of His Lordship having, in terms, permitted the application to be renewed, and in the context of His Lordship following an approach which, in fact, as we see from later on in that document, was relied upon, the Tynas authority, by counsel for the appellant.
I'm sorry, to say that again, that last point?
The context in which I make that submission is, first of all, that the Lordship expressly permitted the application to be renewed, and secondly, his conduct in the 10 or so days prior to that hearing had simply been to exercise his case management powers to obtain proper evidence of the asserted health needs and the impact of that on the effectiveness of the hearing. And that is a matter which, if authority were needed for the proposition that a court is entitled to exercise those powers, that authority was cited by the appellant's counsel in the position statement, the Tynas case. And that's relevant context because criticism is made in that document of the approach of the court, and in my submission that criticism was not only unjustified but expressed in unhelpful terms. It's not helpful, and the court wishes me to address in any great length the submission made this morning about the nature of the position statements, but I don't accept necessarily that it's right to say that they are a collaboration between counsel and client. Of course, they're on instructions, as everything that counsel does is, but I don't have authority for this proposition, but I'm not sure that it's needed. But counsel is not simply a mouthpiece. That is a well-established and familiar principle. And so, insofar as there is criticism made that His Lordship, as I understood it, didn't inquire as to how that tone or that expression came about, I don't accept that. I don't accept that that's a fair criticism of His Lordship.
If it was the case that the applicant, rightly or wrongly, was feeling disengaged and treated unfairly by the court, was it acceptable to put that in some shape or form in a position statement to communicate that to the court?
Absolutely, I accept that. I accept, of course, that if that is a strongly held belief on the part of a litigant, then those who represent them, it may be, I don't say in all cases, but it may well be appropriate for that point to be made. Perhaps if I might put it in less definitive terms than absolutely, certainly in many cases it will be. I can't say in every case, but yes, general point, I don't criticise the fact that the point was made, but I simply make the point that the fair-minded and informed observer, particularly bearing in mind the context of the previous 10 days, would not have been surprised that some critical comment was made.
As my lord said to Miss Antliff in the course of the morning, some of us have a recollection that there is an authority in which a court said it was not appropriate for a judge to threaten or warn counsel of reporting him under or her under the code of conduct in the course of a hearing. Are you aware?
I'm not, no, and like Ms. Antliff, I searched for a similar authority, not because I knew about it, but because so I thought there may be one in preparing for this appeal, and I could not find one. And if
You search Bar Council as well as Bar Standards Board.
yes, yes.
It may be an old copy of the White long before you were called, Mr. Wilson.
Perhaps so, and also in the limited time over the shorter German, I also undertook more specific inquiries in light of the court's recollection, and I couldn't find anything. But if it assists the court, then certainly, and no doubt those representing the appellant would agree, we can make those inquiries after this hearing if that's helpful.
Well, speaking for myself, it may be that our memory, I don't think our case is very strong, but our memory is wrong. But I think it would be worth just, if there are worthwhile inquiry, not absurd ones, that you could have in the immediate aftermath of the hearing. Of course, we would be assisted by any research you could do on that. But just so far as the position statement is concerned, well, we have your submissions. Yes. It's really a question of what are the parts that we're entitled to. The judge is entitled to regard as impertinent and impudent, and you really refer to the same passages as the court did.
Yes, yes. And I suppose there's two questions. That's the first, and then the second is the way in which his lordship expressed that. Was that expressed in such a way that it might give the appearance of bias? And I don't, in writing or now, seek to stand over the comments that were made about the Bar Standards Board. I don't seek to argue that they were necessarily justified, but the point I do make is that in context, bearing in mind the authorities that are very clear that counsel are expected, rightly or wrongly, to deal with, not my words, but the words in the authority, judicial irritation, even where that irritation is, with the benefit of hindsight, disproportionate. Viewed in that context in my submission, the fair-minded and informed observer would not consider that gave rise to an appearance of bias, particularly when seen not only in the context leading up to it, but the immediate context thereafter, because in fact what happened was that was a very brief exchange over less than half a page. The court heard briefly from those representing the respondent and the child. His lordship then adjourned the hearing, granted the application, and then, as the point I've already made, not only did his lordship grant the application, but did so on a basis that was preferred by the appellant and not by the respondent for an additional 2 months, that enabled continuity of counsel. And in my submission, that's a very relevant factor.
So in assessing whether it was evidence of bias, the fair-minded and informed observer would take into account that the substance of the argument put forward in the position statement was accepted.
Yeah, well, they perhaps so, but perhaps not given his lordship's comments. But forgive me, the substance, yes.
The substance.
Yes, forgive me, yes. Yes, the substance that.
Because I'm right. The substance was accepted.
Yes, yes. Perhaps not of every paragraph, but
no,
the
the position.
Yes,
the position which was put forward in the position statement.
Yes.
Was preferred by the court.
Yes.
Over the one that you were advancing.
Well, I should say the respondent wasn't opposing the application.
Okay. All right.
But yes, I accept that the position advanced was adopted, and then when there was a clear dispute between the parties as to dates, narrow on one view, but 2 months for the respondent in these already long-running proceedings is not a small matter.
So on the case management, the
yes.
appellant achieved everything that she wanted at that hearing.
Yes, absolutely, my lord. I'm conscious that Ms Ancliffe took instance 8 next, but that came at the very end of a hearing, so I wonder if the court would permit me to...
No, do it your own way. Yeah.
I'm very grateful. The next matter, if I may, is instance number 4, which is the criticism of the way in which the...
Perhaps I should say, as long as you leave enough time for instance 8, which you appreciate is
Yes.
the most senior.
The only reason I take it in this way is because there is some, not a lot, but some context in some of the earlier passages.
No, of course, no.
Which is relevant.
Yeah, no, carry on.
But I'll be as brief as I can in relation to those that aren't the focus of the appeal. In relation to instance 4, I can deal with this perhaps very briefly. As the court identified this morning, the central issue in the case, or the two real issues, were the relationship between the child and his mother, and the relationship between the child and his half-siblings. And in large part, those issues were needed to be assessed by way of an analysis of the risk posed by the appellant, not only by her actions, but by her unwillingness or inability to accept those actions. Also relevant context is the fact, and his lordship refers to this in his lordship's judgment, it was the express evidence of the appellant at the end of the July 2020 hearing that she accepted the court's findings and that she wanted to move on. And just very briefly, we don't need to turn there, but the reference for that is at page 506. 115, forgive me, it wasn't her evidence, it was submitted on her behalf, that she'd accepted the findings of fact and she wished to move forward. That's paragraph 115. But this portion of the cross-examination was concerned with her 2 months later going to the police and repeating all of the allegations again to the police, and then subsequently, as his lordship found, which is not challenged, attempting to direct the investigation and to prevent disclosure from the investigation into these proceedings. Those were findings that his lordship subsequently made. And so, viewed in that context in my submission, and as I think the court put to Ms. Anker this morning, a central feature, in fact, if not the central feature of the case, was the actions of the appellant, not only in not accepting the findings, but in actively continuing to pursue those complaints in another forum. And perhaps there's no better illustration of how central that is, that when we look at the transcript, the first supplementary question that the appellant was asked by her own counsel was about that issue. Why did you go to the police? I paraphrase, but that is
Can I just ask you about the judgment?
Yes.
The disclosure of the judgments.
yes.
At what point were the judgments disclosed to the police?
In January 2021, there was a hearing because the brief sequence of events is that nobody knew anything about the police report until November, when a force in the area in which the respondent lives undertook an unannounced welfare visit in the relatively late in the evening. Didn't give any reasons for it, but that perhaps understandably caused some disquiet to the respondent. So an application was then made for disclosure to understand why that had been made. That application was granted, although opposed by the appellant, and that was in November 2020. And then in January 2021, the police made an application for having become aware of the proceedings, because as his lordship found, it isn't challenged. The appellant hadn't told the police about the findings that had been made. And they then applied for disclosure of the judgments, and there was a hearing in January 2020 where that disclosure took place.
Disclosure was opposed by the...
As I understand it, yes, because there was at least there was an indication that there was going to be an application for permission to appeal by the appellant. If I recall correctly, that application was not pursued. That was either, and I can check, forgive me, in relation to the disclosure of the judgment to the police, or disclosure of police material into these proceedings. I think it might have been the latter, and I can check because we'll have the orders.
Sorry, yeah. So the mother had gone to the police, made complaints about what?
Well, I can take my lord to the statement, but effectively repeating all of her allegations of fabricated, as the court found, allegations of domestic abuse and coercive and controlling behaviour, and her statement, I can take my lord to it if it helps, raises a number of other welfare concerns and
Yes.
uses the phrase, every time there's a knock on my door, I fear that
That's
I'll
right.
be told that my child has died in his father's care. So it was both false allegations of domestic abuse, but also welfare concerns. The parties to the proceedings then became aware following the welfare visit. There was a hearing in November, which it makes findings about, and then there was a hearing in January to deal with the police application. And as I understand it, that may have been, forgive me because I'm trying to recall matters, but I think there were two elements to that. One was an application for disclosure of the judgments to the police, and that was the police's application. But if I recall correctly, they may also have applied to vary the disclosure order that had been made by his lordship 2 months previously in November to attempt to discharge the order for the police to provide disclosure into the proceedings. That didn't, that variation or discharge was not permitted, and it may have been, if I recall correctly, but forgive me, I will check, that there was a suggestion, although it never came about, that there would be an application for permission to appeal. The reason I say that is because a further period of time was requested by the appellant and granted before the disclosure was to be provided for her to consider making that application. But that's a very long-winded way of giving my lord of answering the question, which was January 2021 was when the police received the two judgments.
And that was following an application
Yes.
by the police to the judge,
Yes.
opposed by the mother.
So far as I recall, my lord, but I'll happily be corrected if I'm wrong.
Shaking of heads. So,
May I
this
perhaps,
can't, well, no doubt, Miss
Yes.
Ankliffe.
if I'm wrong about that, I apologise. Perhaps if I might check the bundle for the substantive proceedings, because that will.
Well, don't do that now.
No, of course.
Ms. Anchliff will
Yes.
deal with it in reply, and we'll allow you just to
I'm
add
very good.
anything relevant on that point if necessary.
The judgment could have been disclosed to the police, couldn't it, for the purposes of the criminal investigation under the rules,
Yes.
without an application.
Yes.
I've just checked in case you think
Yes.
12 practice direction
Yes.
12G.
So why did the police apply? Because they didn't know the rules.
Yes, perhaps so, but it may be that also came about in the course of the police applying in relation to the disclosure order that had been made ex parte to the police in November. But I
Sorry,
feel
did the police apply to withhold information from the proceedings, or was there an application by one of the parties to discharge the order the judge had made?
I don't wish to be unhelpful, but I fear I might be straying into guessing or speculating because I can't recall. But may I ask that we address that?
Yes, I think there's a risk of our getting bogged down on this point.
I wonder if I might, forgive me, but I will certainly find out the answer to that.
Let's just go back to where we were, which is incident 4, pressurising the applicant for reporting
Yes.
allegations of abuse to the police. Your primary point was that this was a crucial question,
Yes.
and that that was indeed understood by Mr. Udine himself, because it was the first supplementary question he asked in chief.
Yes. And very briefly, if I might.
So, okay, we've got your submission that it's crucial. What about the way in which the judge pursued it with the witness, which is, specifically with the mother, which is the real criticism here?
Yes, which is that over the course of 2 pages, that the question was asked more than once. But in short,
It's a little bit more than that. I think it's asked. Take Miss Ancliffe's language vigorously. I noted it being asked at least 5 times. Now, it could be said it was asked that many times because she didn't answer, but
Can you remind us of which page you're on?
225, my lord, is
it's 225 right through to 23. It reverts, comes out briefly at 232, doesn't it?
yes. 225 is the beginning of the supplemental questions and evidence in chief. The first intervention by his lordship about this point is at 227, and
Yes.
it was asked once, but in fairness, I'm not sure the question was understood. So it was asked just above D on 227. It was then explained again and in my submission, my lord has the point. In my submission, the question wasn't answered, and it was a fundamental question. And I accept that the witness was unlikely to turn around and go, because I was lying. But it was a fundamental question, and the answers were confused, because there was some confusion in the answers about the distinction between family and criminal proceedings, etc., which didn't really deal with the point, and it was for that reason that his lordship asked on a number of occasions.
Just remind me, I hadn't fitted into the sequence. Where was it that she said she had moved on?
That was in the judgment following the July 2020 hearing.
Statement. There's a statement. Yes, no, the judgment, the last paragraph.
You
of the
said
judgment.
page 506.
Yes, paragraph 115.
It's not a statement, it's a statement on her behalf by her counsel, therefore, presumably.
Yes,
There is no witness statement from her saying, I accept these findings. No.
not before this court, but she has filed 18 statements, and there's certainly references to her wanting to co-parent and.
Well, that's obvious, but I mean,
made findings.
what her attitude was to the findings made against her by the judge. We haven't seen anything. There may be something, but we haven't seen anything where she says, I accept the findings made by the judge.
No, because as we see from her evidence, she says, I accept the findings, and in that, what she, this is my submission, appears to mean by that is that for the purpose of these proceedings, I accept that the findings have been made. But in fact, the answer and her position comes at page 228, and notably, it's following this answer that his lordship stops asking questions, perhaps because it's the answer that was the obvious one that should have been given in response to the question being asked the first time, which is that just underneath E, 228, your lordship, I did not lie to the police, because that's her position.
In other words, which must mean, so she says, what she's saying, as I read it, is actually I don't accept your findings. I do for the purposes of this hearing, because I want to get the children sorted out, the child sorted out. So, and there we are. But actually, I don't. But she keeps going back to her evidence saying I haven't lied. And, you know, there you are.
And that's, as the court can imagine, that was a central part of the respondent's case, and in fairness, recognised by those who represent the child, because of course, saying one thing but doing the exact opposite, that's inevitably relevant to the welfare analysis. But I don't even accept, even if it's accepted that's relevant, if the criticism is about the way in which the questions were asked, I don't accept that it was inappropriate, because if we look at the questions, the answers given to them were not clear, and it wasn't a badgering exchange in my submission. It was trying to drill down to the answer that was given at 228 underneath letter E on the side. The answer that then, immediately following that, counsel asked, may I continue? And his lordship said yes, because the question had finally been answered some a page or so of transcript later. And then, my lord.
And the judge's question, or not really a question, statement at 228D, I'm going to record you've not given a satisfactory answer to my question. What do you say about that, about the appropriateness of that as an observation by the judge?
I entirely adopt the way in which it's addressed by those who represent the guardian, which is to say that it is a feature of case management that the court is entitled to give the witness an impression as to what the tribunal thinks about a particular piece of evidence. The way in which this judge did it in this occasion was to frame it in terms of writing a note. But also I cite in my skeleton argument the quote from the M&P case about the tribunal not having to appear sphinx-like. Those are the words that are used in that case.
Okay.
In fact, he then goes and asks the question again, or doesn't he? And then the mother gives the answer that she gives at E to G.
Yes. And my lord also referred to when the matter returns at page 232.
Yes.
And again, that is because, in my submission, there was a suggestion being given by the appellant there that she was unaware once she had made the complaint, matters were out of her hands and the police would investigate. And indeed, that's the point that counsel for the appellant made at the bottom of that page. But the key point is that this has to be seen in the context of the evidence that the court had before it from the police, which led to a finding which isn't being challenged, that repeatedly the appellant sought to prevent communication, my words, between the police and these proceedings, and also was managing the investigation. And so that was a question that was asked in response to some confusing evidence. It wasn't pursued any further. Objection was made by counsel for the appellant. A point was made. His lordship said over the page 233, fine.
The exchange at 232, where Mr. Udine first objects, he says, I think that's an unfair question, if I may say so. Judge says, you might do so, but I am the judge. Mr. Udine says, I respect that. Can I just finish off what I'm about to say, if you don't mind? Can I? The judge says yes, and then he is able to make his submissions. And the judge doesn't engage or criticise. Perhaps there's points about it might be said that the judge's observation at 232E is a little bit spiky. Even if that was so, your point is, nevertheless, the submission was allowed to be fully made.
Yes, and the question, his lordship's question, wasn't put again. So even taking the complaint at its highest, an objection was made, it was listened to, and the matter proceeded.
Whether or not the objection was properly made, it was listened to.
Quite.
In fact, Mr. Udine, not criticising him anyway, he makes his intervention after the question has been answered, asked and answered. So,
Yes.
yeah, there we are. Okay, thank you. It's been helpful.
And so, in relation to this instance, in summary, it was a central issue, and when one looks at the transcript, I don't accept that it was vigorous in the way that it was asked. I accept it was asked, the question was asked on a number of occasions, and that was because an answer wasn't being given, and I've made my submissions about that, and I won't repeat them.
Is that all on 4?
Yes, it is. Well, I'm conscious of the time. I know I have some time left, but I will go now to. Well, in fact, before I go to instance 8, I wonder if I might just deal with one other matter, which is the instances 7 and 9, and about the way in which a favourable interpretation of the respondent's evidence was made by his lordship. And the reason I do that is because it provides some context to the later exchange.
So what about 5 and 7?
7 and 9.
7 and 9. I don't accept that his lordship were a fair-minded and informed observer would consider that his lordship put a favourable interpretation upon the evidence of the respondent, or that he was treated differently, or certainly not treated differently or favourably in an unjustified way. And perhaps I might take one exchange, which in my submission, both those representing the appellant and the child have, in my submission, slightly misunderstood in terms of the evidence that was being given, and that starts at page 162. And this is during Mr. Udine's cross-examination of the respondent. And the citation relied upon by the appellant starts at 165, but in fact in my submission it has to start earlier than that at 162 to provide context, because the issue that was being explored here was the respondent's view as to when, and if so how, the twins and the child should be introduced. And we can see that the answer given at the top of 162 is from the respondent is that he understands the recommendation of Dr. Petal. It was put to him, B, that he did not agree with Dr. Petal. The time frame is 6 to 8 months. He says it could be earlier than that, or it could be later than that. is your position you've not yet decided the time frame? And he says no, it's according to the child's understanding. I pause to note, just as an aside, that his lordship then intervenes into the respondent's evidence, giving a view or an opinion which was contrary to the respondent's view, or at the very least minimised, and I don't say that in a critical way, the concern that the respondent had about the impact of an introduction.
Well, your client's view was that it's too soon for consent.
Yes.
It should be at a time fitting A's time frame.
Yes.
I'm paraphrasing.
Yes.
I hope not inaccurately.
Yes.
Whereas the judge's intervention suggests that he thought that, for reasons he explains that intervention, that it could perhaps or should perhaps be at an earlier date.
Yes, and so insofar as the court is looking at interventions made by his lordship, that is an intervention which on any view gives a contrary view to the respondent, supports the appellant's case that the introduction should take place sooner rather than later, but I make no criticism about it because his lordship is entitled to make that observation. But I only say that as an aside. Over the page at 163, we can see that the respondent's explaining on this page what his concerns are about how sharp a child and switched on a child A is. And then about 3/4 of the way down, just underneath F, just next to F, Mr. Udine puts to him, are you saying that it's down to the child to decide when he wants to see the twins? Is it down to you? He'll give me that indication, yes, when it's ready. But immediately after that, at 164, top of the following page, he doesn't need to utter it out in words. Forgive me for labelling this point, but it's relevant to the interventions that are made by his lordship. So then it's put to the respondent, what you're saying is suspend the court proceedings, let the child make the decision, it's his decision, his life, the child can make the decision. Is that it, or have I put it too simplistically? And the judge's intervention is you have put it too simplistically, and in my submission, that's right. It was a simplistic distillation of the evidence.
And Mr. Udine replies, well, I'm sorry if I get criticised about this, but I'm confused about your answers. Your answers do not make any sense.
Yes. And he's permitted by the court to continue asking questions. And towards the bottom of the page again at F, the answer there, the respondent gives his explanation as to how he sees it happening, which I note, for reasons I'll come on to in just a moment, is in line with Dr. Petrel's recommendation. There is then an interruption because one of the children was present. There was then a break. But at 165, matter comes back after a short break. And then here's where I think there may be some confusion as to, and the reason why it's said that his lordship intervened favourably, because it was put by Mr. Udine that he says, counsel, that the child, it's not really a question, but the point is made that the child might not have the ability to make that decision for himself.
Are we at the bottom of 166 now?
Forgive me, we're at the top of 166.
Okay.
That's the question to put.
Yes.
There's then an exchange. And then in the middle, he said, the respondent says he'll take, in my submission, the proper interpretation of that is that the respondent was put out perhaps by that, the point of that question, which is will he have the ability to make the decision for himself? The respondent then says at D, in the middle of the page, he'll take the decision, so he'll make his own decision when he's mature, 16 or 18 years, but that has to be seen in the context of his evidence previously, which is, it's not about him making a decision for himself, but about, as the primary carer, the respondent understanding from the child when he's ready. And then when it was challenged on that, E, the long answer, if you listen to my conversation with this very senior judge, I told him I started the procedure, i.e. delivering the narrative. The only worry I have is he'll ask me, where are they at the moment? The worry I have, I didn't say I would have to wait until that period because he will give me the indication, how he indicates me, without telling a single word, he wants to eat, he's hungry, he wants to go to the His Lordship then intervenes to say he's not saying that the child will make the decision, he's simply saying he will know, his son will let him know when he's ready. That is correct. That is a correct summary of the evidence in my submission. It's used as an example of His Lordship misinterpreting the evidence or shoring up the evidence, but I don't accept that when one looks at it in the context starting from 162. Because then when he's challenged again at the very bottom of the page about, you said something about 16. What did you mean by that over the page at 167? And the answer from the respondent is, if it was the case, and in my submission what that means is, if it was the case he would make his own decision at the age of 16 or 18 and we could just wait for that, he wouldn't have spent the amount of money that he has. He would wait until he becomes legally mature. But he didn't wait for that long. I did not wait for that long. And Mr. Udine says, okay, I misunderstood. Okay, that's fine. But again, just above D, down that page, the same point that's been explored now for a number of pages is put again. Are you saying at any point from now the child can make the decision and you'll respect it? Again, when did I say the child can make the decision? I said indication, 2 different English words. And again, His Lordship, correctly, in my submission, summarises the evidence. Not a case of the child making a decision. He's a child. He'll indicate to his father when he's ready. And forgive me, we're building to the relevant passage, but if we turn on 2 pages to page 169, halfway down the page, underneath D, the question is put, you're asking the court to disregard the opinion of the expert and to leave everything in your hands because you're the best person to make the decision based on what the child says to you. There's answers which I accept don't particularly answer the question, but the question wasn't put in the most succinct of manners, but it was put again, is it your case the court should disregard the opinion of the expert?
So which page are we on?
169, forgive me. I'm sorry for delving into it in such detail. Is it your case the court should disregard the opinion of the expert and leave the matter in your hands? And again, the answer is correctly, he didn't say disregard, because as I've taken the court to, he accepts much of the opinion of the expert, not all, but much. And it's finally, forgive me for the time it's taken, over the page at 170, I then interject to make the point that I'm making now, which is that over a considerable period of time, the same point has repeatedly been put, which was a mischaracterisation of the evidence. And His Lordship summarises the evidence again. And forgive me for the time that that's taken, but it's relied upon by both the guardian and the appellant as an example of the judge misinterpreting or seeking to shore up the evidence of the appellant in contrast to challenging the respondent. But I simply, and with respect, don't accept that. His Lordship was accurately summarising the evidence that had been given. And that's relevant to instances 7 and 9, but I also say that it's relevant up to a point to instance 8 because it provides some element of context to questions having been put by counsel for the appellant. Other references were given, but the court wasn't taken to pages 381, 385 and 387 of interventions by His Lordship's guardian's evidence that it is said were favourable to the respondent. And again, I don't accept that, I won't turn to them, but each of them are perfectly justifiable when the court looks at them. But perhaps more importantly, in the guardian's initial response to the application for permission to appeal, which is in the bundle, at page 23,
Yes.
over the page 24, the first substantial paragraph beginning the mother, guardian at that point makes the point that no complaint is made by the fact that there are interventions to the guardian's evidence as well. And perhaps perhaps I can make a general point because the court has looked at the transcript, so knows the relevant passages. But in particular, the passage in which His Lordship asked the guardian to reflect on her conclusion that the appellant was a child-focused person in light of the findings that have been made, and the exchanges about her perhaps feeling as though she had been mistreated and her being entitled to tell people about that. Again, all of that has to be seen in the wider context, which is that the central issue in the case, as I've said before, was the impact of the appellant's, lack of acceptance of the findings. And the simple point, I won't take the court there, is that His Lordship was entitled to be asking those questions because they were relevant. They were a relevant issue to have been asked. But all of this takes me, forgive me for the time, to instance 8, if I may, move on to that. The court has been through the transcript, so I'll try to avoid that unless absolutely necessary. But the starting point is that when His Lordship says in his judgment that the matter that was put to the guardian didn't reflect the guardian's evidence, up to a point, and I'm careful that I only advance this submission up to a point, that is correct, in the sense that the use of the word trauma is the same, and the general thrust of the point I accept is the same. And so in that sense, I accept immediately that it's fair to make the point, and the fair-minded and informed observer may consider that His Lordship was mistaken. But it is important to note that they are two different matters, and I don't wish to dance on the head of a pin, but they are relevant when one looks at the context, because as the court is aware, and perhaps if...
Sorry, I'm sure you're about to come to it, but just so I can follow, what are you saying? In what respect are you saying that the question didn't reflect the guardian's evidence, having acknowledged that the general thrust was the same and the word trauma was the same? What's the respect in which it wasn't the same?
The difference is that the guardian's evidence was about the loss of the appellant and the wider maternal family to the child. The way that the question was put was that was specifically about the child moving from the care of the appellant to the respondent. And the reason that that's different, my lord, is that when viewed in the context, that's not quite what happened. And again, that's why context in my submission is important, because the child lived with the appellant until approximately the summer of 2019, at which point the twins were born in a European country, and the appellant spent a considerable period of time in that country, and only limited periods of time in this country. She went backwards and forwards. So the primary care for the child from approximately summer 2019 onwards, and certainly the guardian's view of the child's primary attachment figures, were an aunt and uncle in the maternal family and the respondent, because between 2019, or summer 2019 and April 2020, the time that the child spent with his father, the respondent, increased, and they were the primary caregivers. It was only in April 2020 that the decision was made that he would live permanently with his father. And so I'm careful that I don't push this submission too far, because, as I say, I accept that the fair-minded and informed observer would perhaps form the view that His Lordship was mistaken. But when one looks at that question in the context, there is a relatively significant difference between saying that the trauma that's been suffered was as a result of moving from his mother's care to his father's care, on the one hand, which is what was put, and on the other hand, saying that over the course of this child's childhood and the various different care arrangements that he has had, the loss over time of his mother and his maternal family in those care arrangements will have caused trauma.
Well, one objection to that submission might be that the question was interrupted. on the bottom of 370. And I think the point that you made, I think the law made this observation, certainly it was my observation. I noted the difference to which you're referring, in that the guardian did not mention to the care of the father in what she said in the passage at 360.
Yes.
She said it was leaving. He must have suffered trauma and loss, losing his mother out of his life, and all of his extended family to him was very close.
Yes.
Now, you don't know what Mr. Reedy was going to say, but he was clearly interrupted, and it's possible that the words "leaving behind" might have been followed by words paraphrasing what the Guardian had said at 360 DE.
Yes, and I don't, and I couldn't argue against that. That might be the case, and the question wasn't.
So if the question had been completed, it may well be that the phrase "to the care of the father" would have been a minor or incidental interjection to the question, which was focusing on the traumatic loss. That's the problem. Is the judge interrupted before we got to the end of the question?
Yes, and I well accept that. I don't seek to argue against it, and as I say, I hope that the responsible position in this respect is put as fairly as possible. That is a fair comment, and I accept that. But if I may, just make a few points about that. The first is that, and this doesn't meet that point directly, I accept, but another element of the context to this is that, of course, it comes about in the course, in a hearing where, during the course of the hearing, not beforehand, only during the course of the hearing, the respondent sought to reopen the question of where the child was living. That was not in any of the documents beforehand. It was first raised during the course of the hearing.
Sorry, so I thought I heard, I've written down the respondent sought to reopen, the appellant.
Forgive me, the appellant. I'm grateful, my lady. The appellant sought to reopen that question. But also, in the context of a hearing and evidence, as the court would have seen having read the transcript, where the appellant's evidence is full of both new and old repeated criticisms of the care that the child receives in his father's, while living with his father. And so again, I say that because it emphasises the difference between the 2 points, which again, I don't make this point too strongly, but there is a difference between what appears to have been being put and what was in fact said by the guardian. But again, I accept the point that doesn't mean...
Well, again, Mr. Wilson, forgive me for interrupting, but if we go on to 372, when at the top of 372 the judge, Mr. Eden, asks, "May I ask that question again or not?" and the judge says, "Certainly." And the question is then put, does not refer to the father at all. The question is about. I mean, that, at first blush, and something that you may say, I think that's a pretty accurate. In fact, it's almost word for word what the Guardian had said at 360.
Yes, I accept that, but that's not the way in which the question was beginning to be put, and I accept
Yes.
the point. There is no response I can give.
Well, I mean, well, all sorts of things are possible, Mr. Wilson, but that's a further point
it is,
against you, perhaps, on this point.
It is, but the point I do make is that that is very much not the way the question was put at 370, because it was squarely framed in terms of moving from mother to father, bearing in mind, of course, that the case that was being put at that point in time was that the court should reopen a question that had been decided well over a year ago about where the child lived, and it should do so on the basis of a raft of criticisms of the respondent's care to such an extent that, and I've referred to it before, but it's important, that the appellant expressed to the police at least that she feared that her son was going to die in his father's care.
That's reading a lot into a few words in the sentence, isn't it? that whole package of
Well, it's
past
the context.
should
Of
be
course,
read
I
in.
don't. That wasn't.
I mean, if he
but-
just said, moved away from the Zaman, leaving behind, we don't know what he was going to say next. It's sort of the reference to the father that seems to have, that you say is inaccurate, because in fact the child went from mother to mixed care, progressing to father.
Yes, and yes, I accept that.
Of course, we weren't there.
Yes,
We don't have a recording.
quite. But
And if one can envisage that those words might have been put in a way which led the judge to think what you're suggesting, namely that the interjection, the insertion of the reference to the father here that's what the judge was objecting to.
yes,
And perhaps the other context possibly, as you pointed out, is on previous occasions, perhaps we got a greater justification. The judge had found Mr. Udine asking questions in a rather inaccurate and tendentious manner.
yes, and forgive me. That was why I burdened the court by going through that lengthy exchange.
No, I know, but I was just seeing that's how you say that. But what strikes me also looking at this exchange again is it doesn't look as though the judge was particularly cross at that point. It is an intervention. Right, if Mr. Clark said that I didn't hear it. And over the page, all I'm saying is I do not recall her saying that. It really takes off in the following exchanges after Mr. Udine has said, what would you like my lord to do? Not even ask the question because your lordship hasn't heard it. That's the point where the judge A gets much stronger. Well, he did not say it, and then really becomes clearly
Yes, and
irked. Let's put it no higher. Do not talk to me like that, and so on. Yeah, I don't know quite what I get from that, but I share that with you as a possible way of reading it. That what we really have here, when the thing really becomes quite dramatic, as clearly everybody found it did, it wasn't at the bottom of page 370, it was the top of page 371 with a slightly different trigger.
well, my lord, that's exactly the point I was going to come on to, because even if I'm entirely wrong in my attempt to demonstrate that there was a difference between the way the question was put and the way the evidence was given, even if I'm wrong about that,
Just on that point before we go, I think Mr. Bow, up to that point, is with you, isn't he?
Yes, he doesn't. Yes,
I think, doesn't he suggest that the question was
he does.
not quite right?
Yes,
Yeah.
right. And even if I'm wrong about that, and even if Mr. Bow is wrong about that, and even if the judge was mistaken, in my submission, if the matter had moved on, then nothing could be said. I accept, in fact, rather not just accept, the point that I make is exactly the point that my lord has just raised, which is that, with the greatest of respect, whether it's right or wrong, what escalated, for want of a better word, the situation, what led to the remark at the bottom of the page, was the response from counsel for the appellant, and I make no criticism about that. But an important point is, after that exchange in the first third or so of the page, not only is the point about should I not ask the question if your lordship's not heard it, but also, well, let us hear what she says then, my lord. And again, it cuts both ways. I accept the court doesn't have the tape to listen to the way in which his lordship expressed himself, but the court also doesn't have the tape to understand the way in which all counsel expressed themselves.
Yes,
And if I
those words from Mr. Udine are the words which the judge objected to.
yes, and
Let us hear what she says then, my lord. Do not talk to me like that.
there's 2 points that I would make about that. The first is that, in the same way, although perhaps to a lesser extent than the March incident, it's not out of nowhere. Whether it's proportional or not is a separate question. But if some comment be made by his lordship at that point, in my submission, the fair-minded and informed observer would not necessarily have been surprised about that. But what's particularly important as well is that immediately following that exchange, his lordship's response is to say, carry on, and there's a response to that isn't carrying on, then now ask the question. That's the second time, and counsel says no. For a third time, the judge says ask the question. Counsel, again, doesn't ask the question and expresses his view. And then, after a further exchange, under F, the fourth time, his lordship says, will you please just get on with asking your questions? And particularly important here, before I carry on, is that distinction between unfairness and bias, because as the court has pointed out, in one sense, whether or not the impact that it had on counsel is one matter. It's about the appearance as to bias, bearing in mind that definition, which is a prejudice against a case or a litigant on the basis of, unconnected to the legal or factual merits of the case. On 4 occasions, his lordship says, get on and ask the question. And on 4 occasions, the question is not asked, but a point is made in response. And then, importantly, for a 5th time, at the very bottom of the page, admittedly I accept after the comments about the bar standards board, please get on with your cross-examination. Counsel asks, may I ask the same question again or not? And his lordship says, certainly. The question is then asked. Separate matter as to the answer that's given, and I'll come to that in a moment because I accept that that's a relevant point. But just pausing there for a moment, the 2 points that I invite the court to take from that is, first of all, what led to an increasingly heated exchange on both sides was not the question, but a comment that was made by counsel. Whether that's right or wrong is another matter, but that seems to have been the catalyst. And the second point is that throughout, his lordship is saying, ask the question, and counsel, rightly or wrongly, is not doing that. And so again, it's stepping in the shoes of a fair-minded and informed observer. In my submission, what that individual would have observed was an exchange which I don't seek to suggest either party to it would look back at the transcript and with the benefit of hindsight have thought that that was a productive exchange, but an exchange which led to, on many occasions, the judge saying, ask the same question. And then the point we get to is that a similar question was asked, and the guardian gave the evidence that she did. Again, I'll come back to that in a moment because I recognise.
So, on your interpretation, the bar, does this follow? The bar standards board is mentioned. I understand you're not putting it like this, but is this in effect what you're saying? After the judge has directed counsel to ask his question on 4 occasions, and counsel hasn't done so.
Yes, that's the context to it. Now, whether or not...
Instead, counsel has said what we see him saying.
Yes. My submission is not that, with the benefit of hindsight, that is a proportionate response on any view. I accept that this court and that the fair-minded and informed observer may think that that response at the bottom of the page was one that should not have been made. But again, it's about reference to the authorities that I've referred to in my document about the spectrum of judicial, again, not my words, but in the authorities' misconduct in the sense of how a hearing is conducted. And it's about the spectrum of responses from a judge. And as I say, I'm not submitting that that is a proportionate response, but my submission is that when considering the question of bias, the issue is not strictly about counsel, although of course I accept it's that the way a judge engages with counsel could be indicative of bias. Not in this case, I mean as a general principle, I accept that. But and this is a point, in fact, that's made by Lady Justice Black, as she was in Re G, admittedly an unfairness case, but in that case she says very clearly it's not about the counsel involved. In that case, it's about the fairness. In this case, it's about the view.
Is one way of putting it what you're saying? Really, what we have got here, what the fair-minded and fully informed observer who'd seen the whole thing, the whole hearing, would say is here, perhaps also on the earlier hearing, which ends in the same way with a threat to report to the bar. You have the judge reacting disproportionately to a unfortunately expressed observation by counsel, in case in writing here, what we see at the top of the page. And saying variously in the context of that very heated exchange, which may show that he's unduly irritable, but does not show that he has any bias against the mother's case. They're two separate things. You can have a judge who does respond wrongly to particular things said, and if they happen to be said by one party counsel rather than the other, that may look as if it's directed at one, but in fact it's not directed at all. It's just directed at a piece of conduct which he overreacts to and doesn't tell you anything about how he's going to approach the issues in the case. I put it badly, but I'm just trying to. That's the distinction where you're trying
Yes, absolutely.
to
My lord,
persuade yourself.
much better than I had. That's exactly the point that I'm making, my lord. And the logical extension of that as well is that the overarching submission that I make is that each of these instances has to be seen in context. And when that exchange is seen in the way that my lord has put it, but is seen also in the context of the decisions that his lordship made.
Yeah, well,
at the end.
that's the point you've made.
Yes,
you
quite.
made.
And so this in particular
started.
has to be seen in that context. But yes, my lord, that's exactly the point that I'm making. And
Isn't it the other way around then? If you're saying that we need to look at the whole context, including the outcome, then that's to look at fairness, isn't it? Substantive fairness. What was the outcome? Did anything actually go wrong? And I thought we'd agreed earlier in this hearing that this is all about appearance of bias, and you don't get to looking at substantive outcomes and things. It doesn't really matter what the witness would have said or what the outcome would have been. You look at what the perception of somebody independently minded and informed sitting in court might have thought at the time.
yes, absolutely. But forgive me for not putting it with more clarity. But when I say outcome, I mean specifically the paragraphs that I took the court to at the beginning of the judgment, which refer to the relationship and the positive relationship and the importance of the appellant to the child, and the fact that the adjournment was on that basis. So when taking a step back and viewing and asking the question, the fair-minded observer, would they consider there's a real possibility of bias? They would see this exchange and the impact it had on the guardian's evidence, which I know I've not yet addressed, in light of those paragraphs in the judgment. And at the risk of sounding like I'm trying to avoid it, which I'm not, before I come to the impact on the guardian's evidence, I wonder if I might just ask the court to turn on to two further points in the transcript which provide some context to the exchange with counsel. Forgive me, I'm conscious of the time. Those are at 376. I won't dwell on it, but that was after there was a short break, not when it was asked for, but not a huge amount of time later, and that was a short explanation or address that was made by counsel. And then also, when the recusal application was made, this is a point.
.402 is the recusal application.
I'm very grateful.
The judgment, the ruling is at 405.
When it was made, it's a relevant point in my submission. The counsel said, and I accept that the court will recognise that this application was made at the time, and so there wasn't days of time for proper reflection, but that was when the application was made. And the submission made was there have been issues in the interactions. As an advocate, I have brought shoulders. If this application was based on today's interaction, I would not make the application. If it was based on previous times when your lordship, in relation to the position statement threatened to report, I would not make the application. That answers the question that was asked this morning about who introduced the link between the two, and it was counsel. And the rest of the application, and admittedly it was made shortly, but was made largely on the basis of the other instances, although I accept it's returned to at 403 that went to the BSB. And so I will accept the obvious response to this is that one interpretation of that is that it's that taken in isolation, it's not alone, but cumulatively, that's the point that's made. I accept that. But it is important that those submissions were made because equally the fair-minded and informed observer would be aware of those. And that was how the application for recusal was put at the time. But returning, finally, if I may, to the point about the impact of it on the guardian's evidence, I accept, of course, that it had the impact of the intervention. Thereafter, the guardian incorrectly said she didn't recall using the word trauma.
But she also said that Mr. Uden misquoted her.
Yes, and again, I mean that returns to the point about the subtle but important distinction in the way that it was put. But yes, I accept. I'm not trying to shy away from the fact that in following that exchange, the guardian
Nobody had the transcripts like we do and can see exactly how all this arose.
quite. And if I may,
there was obviously quite a lot of confusion about what she had said and the respects in which Mr. Odim's question may or may not have differed from what she said.
The key point is, first of all, and I made this point, is that the question was permitted to be put. But secondly, I accept that the guardian said that you are misquoting me, but she doesn't specifically disavow the use of the word trauma. She says she doesn't recall using it, but she's not saying that it's not correct. Now, again, there we I suppose stray into the issue about fairness, because it's about whether it had an impact on her evidence. But again, the impact on the guardian's evidence is that there may well have been an impact, but it's about, again, coming back to that question of prejudice. And so, in that sense, the impact on the guardian's evidence is of less relevance. But the evidence that she gave then, in response to the question about being confused, good relationship, etc., that evidence, I take on board the point that was made this morning. On one view, and I accept that it's arguable in the other direction, but on one view, if that exchange had been removed, that may well have been the evidence that's given. It's speculation because that's the territory we're in, but that's one point I would make about it. The second point is that, just by way of an observation, that Mr. Bow, who had represented the child throughout, senior junior counsel, did not at that point interject to make any observations in respect of his client's evidence, and that's also a relevant point when looking at the exchange as a whole. But
just a small point. Was Mr. Bow asked either way what his attitude to the application for recusal? Was
no,
he didn't associate himself with it, but nor did he. He just didn't. Wasn't his application. Nobody asked him what he thought.
Quite. And I suppose one point I would make is that the application wasn't made at that time on the basis of the impact of it on the guardian's evidence.
I see. Yes, sorry, that's a slightly different point. But I was just reminded me of the other.
No observations were invited or made by myself or Mr. Bow. But again, when looking at that question of bias, it's also relevant to look at what happened subsequently, and the cross-examination continued for a considerable period of time. Points were put. There was one interjection from his lordship that, as often happens, led to loss of a train of thought, and his lordship apologised. No complaint is made about that. And the cross-examination continued. Also, it was the guardian who invited the court to adjourn. And in fairness, his lordship gives an indication in the transcript that was his thinking, that was the guardian's position. And that was a position that was accepted by his lordship in the judgment. And so the point I make, and I appreciate the court does this, is that it's an unfortunate exchange, and it may or may not have had an impact on the guardian's evidence. But when considering whether or not a fair-minded and informed observer would consider it gave rise to apparent bias, viewed in the context of not only the hearing as a whole, but that cross-examination of that witness as a whole, in my submission, it falls short of that. And it wouldn't give rise to that perception of bias. May I ask any further in relation to that instance?
Not as far as I'm concerned.
I'm grateful. If I might just have one moment, I think I've addressed those points. I haven't addressed instance number 5, which is about the making or not making of notes. I can do so if it assists the court. I don't propose to give any evidence about what was or wasn't.
Almost nothing was said about it. I'm just trying to remind myself from my notes. What was Ancliffe said? Sorry? Yeah. I don't think you, unless you want to add anything, I think
I've
it's
dealt
all
with
in
it
your
some length in
submissions.
my written in the skirting argument. I don't think it's helpful for me to address any further. May I just turn my back?
Yes, sir.
There's nothing further I wish to say about any of the individual instances, and at the risk of repeating myself, I finish where I started really, which is that if we draw the parallel between bias and unfairness, and we look at specifically the test for bias, and we view the proceedings as a whole, really the focus has been on the sum total of about 10 or 15 pages of a transcript of a 5-day hearing, and I accept that it's not only situations where a court has been, where the court is looking at conduct throughout every day of each day of the hearing that bias can be established. I accept, of course, as a matter of principle, a single incident could give rise to that. But in the context of this case, we are looking at very specific examples, limited examples, in the context of an otherwise lengthy hearing at which, forgive me for stressing the point again, the fair-minded and informed observer would be very clear in my submission that the appellant was permitted to put her case, some aspects of it more meritorious than others. By that I'm specifically referring to reopening the issue of where the child lives. But that was allowed to be put, the extra evidence was allowed to be adduced. She was permitted to address the judge encumbered by being asked questions, and I haven't yet found reference that I said I would, so I'll do that. And so looking at all of that in my submission, taken as a whole, apparent bias is not established. And I conclude with the caveat, which is made very clear in almost all of the authorities about either unfairness or about apparent bias, but in particular Re-G, which is in the bundle, and the Seraphin case, which is that, of course, the one person the court has not heard from is His Lordship himself, who would, on any view, have a valuable contribution to make. And while I accept the principle that where bias, where there is any doubt, it should be resolved in favour of recusal, the countervailing principle is that because the court does not have the opportunity to hear from His Lordship, because the court was not there, and the court only has a transcript which inevitably can't capture everything, the court also has to make, the phrase that's used is generous allowance, that is in Re-G, at page 328, paragraph 31, for that fact. And I would like the court to do so.
Thank you very much, Mr. Wilson. Yes. Ms. Ancliffe, anything to say on the floor?
Lord, may I briefly just respond to a few points by way of confirmation of some and clarification of others. So far as the disclosure of material to the police is concerned, I can confirm my instructions are that January was when the transcripts were made available. And so far as...
So the transcripts, you mean the judgments?
The judgments, I'm so sorry, yes. So far as the mother's position in relation to disclosure is concerned, my instructions are that there was no objection on the part of the mother to disclosure.
Did mother give the police some of the documents from these proceedings as well as the judgment, or not?
I'm not sure that did happen. May I just confirm? No, my lord, no. So far as the police application is concerned, I'm informed that the January hearing, when the police sought to attend, and Mr. Wilson will tell me if I've misunderstood what I'm told in relation to this, is that the police were responding to the judge's request for disclosure, and they submitted, perhaps unusually, a PII application saying that it was not in the public interest to disclose the information, and the judge took a different view, overruling them and ordering the disclosure to be made. I'm just going to pause, and Mr. Wilson will tell me if I...
Does that ring a bell, Mr. Wilson?
It does, yes. I'm just looking for the order, but I think that's
Well,
right.
okay, we'll come back at the end if you disagree then. Yeah.
And the mother's position in October 2020, again, I'm just going to pause, and Mr. Eden will tell me if I've misunderstood the note, but the mother did disclose to the police at that point, providing a statement from the family court, and of course by that point, forgive me, I just clarify this. Yes, so of course no judgment, I'm told, in clarification was provided in October 2020, but the mother says that she informed the police about the court's determination in relation to domestic abuse. May I then just deal, if I may, just briefly, insofar as the issue of the interpretation of the father's evidence is concerned, and I'm not looking to review it in full detail. Of course, Mr. Wilson's taken you very carefully. What he says is the analysis of the judge's involvement in the father's evidence, and this is at 166, and he's taken you through all of those paragraphs. My lords, you'll have your own, my lady will have your own interpretation of that, and so there's no real point of me putting another gloss on it. But just reading it again, as Mr. Wilson was taking you through it, I don't agree with that interpretation at all. The word his own decision is very clearly set out there. That is the father's evidence, and that's at D166. He very clearly says in his response, this is in relation to the child, he will take his own decision when he is mature, 16, 18.
Well, let's just have a look.
Yeah, I'm trying to...
No, I appreciate you're trying to be succinct, but I think if this is a verbal point of that sort, we'd better just check it. So 166, yes, D, he says he will take his own decision.
Yes. So Mr. Wilson's tracked it back further, but the point is very simply made. It's this, that is the evidence the father gave at D166. That is what he is saying. He will make his own decision when he's mature, 16, 17. And that is what he continues to say. My lords, continue... follow through where it carries on. At 167, the question put at C, and then the father is there again. When did I say that Ian can make a decision? I said indication, sir. Two different English words, which is the point that was made. But my lords have that he said that is his answer at 166D. He'll make his own decision. It doesn't say indication, it says decision. And then his lordship intervenes at 167D, bit further past where Father's just said these are two different English words.
Yes, no, we can see what he says there.
Yes. And so, as I say, my lords, I'm not looking to put my gloss on it, but just reading it again,
That's helpful.
it's not accurate to say that the counsel on behalf of the appellant mother and counsel on behalf of the child had misunderstood. They had understood, and the submission that's made in relation to that, I invite the court.
Where does the witness use the word decide or decision?
The word decision in his answer is at D166.
I mean, it is confusing. He first does say indication. That's in the passages we referred to at 163
Yes,
between F and G.
yes.
And he uses the words indications in his other.
But the language changes at 166.
No, I see that.
And that's when his lordship intervenes. He says, well, I think you've got this wrong. But that is in the context of the father now using that word and then wanting to go back on it at 167. And
Well,
say,
he goes back to indication in 166F.
Yes. Yes, exactly. So there's an interchange.
The only time he uses the word decision is at D.
Yes, but that word is nevertheless used. And Mr. Udin, we can see when the father uses that word decision, uses that word in his next question. So 166D, he says he will take his own decision because the father's just used that word.
Yes.
And then he is criticised for misunderstanding the father's evidence, when in fact the father is interchanging that word, and Mr. Udin is simply putting his question based upon what the father has just said. And then there's an interjection from Mr. Wilson at 170 at B, very politely raising with his lordship, terribly sorry to stand up in the middle of cross-examination, but repeatedly Mr. Udin is putting a mischaracterised account to my client's evidence. Not helpful. And then his lordship replies, well, my pen is resting on my notebook at the moment. And I think all of that needs to be looked at, not just 163 as a selected line. There is an interchange between the wording here. Mr. Udin is perfectly entitled in my submission to have picked up on the word decision because that's what the father says in evidence and follow that through. My lords, in relation to the judge's questioning of the mother and asking her at least 5 times about the police matter, it is right to say, and I accept that in that passage that my friend took the court to, that in July it was said on her behalf that she would be seeking that she saw that the mother wanted to move on. Clearly the position was different because the mother obviously had pursued the matter with the police, but the contextualisation of her pursuing the matter with the police is important and relevant, and my lords will have in the exchange with the judge seeking clarification of her answer. I'm not going to take lords to it unless you wish me to, but her giving an explanation and analysis as to how it came to be that that matter returned to her mind, that she'd spoken to domestic abuse workers and that they had told her information, and as a result of that she understood that matter was still open to be pursued. So there is a contextualisation. I'm not saying that contextualisation necessarily helps her, but it is important that when one is making submissions, we don't just pick out bland points like he put it 5 times, she wasn't really answering the question, because there's a depth there that needs to be looked at, and the depth of it was the mother trying to explain to the court how that had come about, that there'd been other discussions with professionals, that professionals had suggested that this was a separate matter, and whether that chimed with the judge's view or not is separate, but to be asked so many times, 5 times on that point, I return to my original point this morning. about that being excessive. May I just very briefly invite my lords to look at the exchange between counsel, Mr. Udin, and his lordship in the August exchange, which has been the subject of much of our
370.
Yes, thank you very much. And my lords, simply just to make this point that I think my lords have the point that at the top of 371 is when, if I could use colloquialism, things kick off, and his lordship is obviously upset by the way that counsel is expressing himself. And it's at that point that things become heated, and the direction of exchange becomes, in my submission, inappropriate. It's not the point when his lordship says, if you carry on like that, I'm going to report you for Bar Standards Board, or consider doing that. It's this point. It's this is the starting point of that exchange.
Well, Mr. Udin saying, well, let's hear what she says then, my lord.
Yes, from that point onwards. And it's clear.
Well, even I think from the answer before.
Yes, from the answer from the top of that page, but certainly by the time he's saying, well, let's hear what she says then, because that very remark seems to trigger the judge to say, do not talk to me like that. But it's clear from Mr. Udin's responses then, and again, it's the contextualisation of this part of the exchange that's important in my submission, is that Mr. Udin is asking for some time. One wouldn't be asking the judge to give 5 minutes if one was able to carry on and be composed. So when it's submitted on behalf of the respondent that Mr. Udin is in fact just being asked to get on with it 4 or 5 times and not doing so, and his lordship has no choice but to really express himself in the strongest terms. And I know that, and I'm grateful to Mr. Wilson for distancing himself from the ultimate expression of reporting to the Bar Standards Board, but nevertheless, the contextualisation of this is a barrister who's unable to compose himself in the moment, asking for some time, not being given that time, and his lordship saying, well, let's just get on with it. Ask your questions, ask your questions. And one has to read the responses of Mr. Udin to get the proper context of this, because we see at F, after he's asked for some time and he's not given any time, we can see at F that he is saying to his lordship, I will, but can I have it, I don't know if affirmed is the right word, but that's what it says on the transcript, affirm from you that you will not talk to me in that way. And so those remarks are relevant because they might point to how this barrister is able to conduct himself in that moment. So it's all very well saying, just ask your questions, but one is perhaps shaken by what's gone on, one is trying to compose oneself, one is trying to ensure that when the hearing properly evidentially resumes, that one can carry on doing the job. And I think it's, in my submission, important that those parts are also considered by my lords and my lady when you retire. So far as the personal statement is concerned, my lords have that personal statement, and that is at 376. And Lord, I didn't, my lady, I didn't take you to that personal statement because I think it speaks for itself. But the relevance of that personal statement, again, is the contextualisation of a barrister who's trying to compose himself again, trying to do his job, trying to...
Sorry, the personal statement, yeah.
The personal statement at 376.
Oh, I'm so sorry. I thought you meant the earlier personal statement.
No.
Yes, no.
No,
Now I've got it.
Yes,
no.
There's been a break, and
yes.
Again, if one looks at the sequence of what's happening here, is the judge saying, well, let's just get on with it. Counsel's obviously expressing difficulty about being able to do that. Whether he's doing that effectively or not, that's what I would submit he's trying to do, and then there is a break, and then he's explaining to the judge the impact all of this is having. And so I would invite my lords and my lady to have a look at that, again, in the context of what's happening here at this point in time, before we get to 402, when he is making his proper application for recusal. I don't think that my learned friend Mr Wilson was saying that the application can be limited to those points, because of course he's thinking on his feet. He's making the points he can in the moment that he has, in the moments that he has, to think about what the issues are. He's, one might consider objectively, trying to still keep a bit of a balance going here. This is still the judge. He's obviously apologised to the judge. One can see in the transcript that he said that if he'd been disrespectful, he didn't mean to. He was sorry for that. And so there is balance here. He's trying to be balanced. He's trying to make the application because he's been instructed to by his client, by his solicitor to do so. The points obviously have been expanded quite properly after the event, when he's had time to reflect and when there's more material upon which to reflect, when transcripts are available. And my lord made the point about no transcripts, of course, being available at the time when the evidence is being taken and misunderstandings happening in that context. Of course, one accepts that in every trial, misunderstandings do occur, and evidence may be misheard or evidence missed. The consequence of the parts that my lords have looked at and my ladies looked at are significant. And I would say that if there was some, and an issue was being taken about what the Guardian had said, forgive me, I should have prefaced the point I'm making is in relation to the Guardian's evidence, but what the Guardian was saying, very easy answer, and we often have this when it occurs, is to check the note against each other's at the bar. That's the first point, isn't it? That we all check the note. What did you say? What did you record? There was none of that in this case, which is perhaps unusual. And if it's a very important, significant point, the tape can be checked. That's the point of having the tape. But none of that was done. But his lordship took the very clear view that he hadn't heard it, that it hadn't been said. And that isn't, in my respectful submission, the right approach. So yes, of course, there wasn't a transcript, but the other mechanisms are there and are there to serve to ensure that proper evidence, clarity of evidence is available to the court. My lords, my lady, if I in any way suggested an improper test on the law, I don't think I did. I apologise. Very clear what the test is, and that there was an overlap that was being considered in relation to fairness. So I hope I didn't, and I'm responding to one of their friends' submissions, in any way suggest a different test.
You're content with the test that Lord Justice Leggett put forward in Bubbles and Wine?
Indeed, yes. Thank you.
If it was Bubbles.
If I can assist in any other way.
No, we'll just rise for a minute or two and see where we are. Thank you.
Court rise.
May I
Yes.
correct one matter. I'm so sorry,
Yes.
but I made the submission that there wasn't a judge lined up to hear the matter if the appeal was allowed. And I did make that point, but when I was on my feet, I've been told that there is, in fact, and it's the president of the family division, so there is a judge.
Good. Thank you for letting us know about that. Well, we're not going. Well, I'm sorry. I was going to say thank you to both counsel for excellent submissions in a difficult case. We are not going to make a decision straight away, but it is obviously important that we do so very soon because of the imminent hearing. But if we do that, you, I think, are likely at that stage only to get a decision with reasons to follow, because preparing the reasons will take a little time. So all I will say is that you will have a decision as soon as we can give you one. I don't think there is, I'll put it another way, if counsel are able to find this phantom decision about referral to the Bar Council in the next 24 hours, please let us know. But don't bother thereafter. And also, please do not don't spend sit up all night. It may be a phantom that you're chasing. But if some thorough research could be done in that time scale, would be very helpful.
Hand down judgment. You said about hand down.
Well, no, my lord makes the point, and perhaps I should say this. It's a slightly different position, because if, as seems likely, we will give you a decision before reasons, the decision will, I think, have to be formulated as an order, rather than just this is what the order will be in due course, because I think everyone needs an order to work with. So what would eventually be circulated to council in the usual way would be reasons, and that would be submitted for corrections and probably also any consequential matters that haven't had to be dealt with straight away. The ordinary warnings about confidentiality would not apply to the same extent, because the order had already been made, but nevertheless, as a draft, it would remain confidential, and you're aware of the constraints on publication of the reasons before formal hand down. Yes, thank you very much.
Thank you very much.
Last three, the second countdown.